So welcome everyone to the very first edition of our life sciences sessions. I hope you can all see me. I hope you can all hear me. My name is Philippe de Jong. I'm a partner here at Altius. I work in the intellectual property and life sciences departments, and I will do this presentation today together with Kirian Claeyé, who's my colleague, managing associate in this firm, and also specializing in life sciences and intellectual property. So the life sciences sessions is a new concept, a new format that we created because we believe it is important to continue to engage in interaction with our clients in context despite the present crisis we are in, but we have every intention to have this format continue beyond and regardless of the crisis. So this is only a first. And obviously, this service, so to speak, will come in addition to the already existing services that we offer. You're familiar with our pharma law seminar, agri-food law seminar, both of which we consider to be covered by the term life sciences, and obviously also the blog posts, which some of you receive by email, which can be read on our website. And so the idea of the life sciences sessions is to have a bi-monthly because in the months in between we will have other sessions on intellectual property. There will be further announcements on that sometime soon. But bi-monthly presentations whereby we will give you an update on a topic that we believe to be of interest, either because it relates to newly developing areas of the law or because it's about a topic that has been on the radar for quite a while, and for the reason of which we believe it is useful for you to get an update or an overview. So in the latter category, and because we had to start somewhere, we decided why not give the first presentation on parallel imports, because it's a topic indeed that has been around for quite a while, but where there have also been numerous developments over the past couple of years. So we have a lot of things to talk about. We have a lot of slides as well. Time will tell whether we have too many slides, but we will have to see. We will focus predominantly on the intellectual property aspects of parallel importation, although at the end of today's presentation, we will also deal with a number of regulatory issues. So without much further ado, I will dive into it. This is the outline, which basically summarizes what I just said. So I will start with the trademark chapter. And for those of you who may be less familiar with the concept, although I assume most of you are familiar, so I think I can run through this quite quickly, is that a trademark obviously offers the trademark proprietor an exclusive right, and notably the exclusive right to prevent third parties who do not have his consent from using, amongst other things, identical signs for identical products. And this use in the trademark legislation has been defined quite broadly as affixing the sign to the goods or to the packaging of the goods, and to use or to engage in certain activities then with these goods and that packaging. So anytime somebody comes along and uses your trademark and affixes it to a product or a packaging of a product, that is a form of trademark use. And hence, if the party in question does not have your consent, an actionable right of infringement, an actionable infringement. The only exception, well, there's a number of exceptions, but there's a big exception, which is the concept of trademark exhaustion, notably that the exclusive right of the trademark holder cannot be exercised against goods that were put on the market by the trademark holder with his consent. So that is called exhaustion, which most of you are familiar with. Now, there's an exception to the exception, notably that the trademark holder can exercise his rights in such a scenario where there are legitimate reasons for the proprietor to oppose a further commercialization, notably where the condition of the goods is changed or impaired after they have been placed on the market. Now, it gets even more complex than that, because the Court of Justice has said that that's all very well, these principles of trademark law, but you need to align them with the principle of free movement of goods, which exists in the European Union. And according to European law, there can only be restrictions to the free movement of goods on a certain number of limited grounds, including the protection of intellectual property. However, the Court of Justice has said you can impose these restrictions only to the extent that they relate to the specific subject matter of the trademark. Thank you, Kirian. The specific subject matter concept is something that has been developed by the European Court of Justice in the 1970s, 1980s in respect of pretty much all intellectual property rights. And specifically for trademarks, the specific subject matter is essentially the right to place a product bearing the trademark on the market in the European Union for the very first time. And according to the Court of Justice, that also serves the essential function of the trademark, which is to serve as a guarantee of origin. So that definitely means, of course, that any form of repackaging, according to the European Court of Justice, always affects the specific subject matter, and therefore, in principle, always provides a right for the trademark holder to oppose a further commercialization of the repackaged product. Unless, and here we are in the exception to the exception to the exception, unless the parallel importer meets a number of criteria, which over time have become known as the 5 BMS conditions, BMS standing for Bristol Myers Squibb, because it was named after one of the first cases of great importance in this area. And so to the extent that the parallel importer can show that the trademark holder's opposition against the further commercialization of the repackaged product would lead to artificial partitioning of the market, and to the extent that the repackaging does not affect the original condition of the product in the packaging, and the identification of the repackager and the manufacturer is provided on the packaging, there is furthermore no damage to the reputation of the trademark holder or the trademark itself. And to the extent that the parallel importer has provided prior notification and, if requested, an on-demand specimen to the trademark holder, if all these 5 conditions are met, then he may put the product on the market in repackaged form. The European Court of Justice has confirmed afterwards, because most of the cases that are out there, and also most of the ones that we will deal with today, they all deal with pharmaceuticals, but the European Court of Justice has already emphasized a number of times that these BMS criteria do not just only apply to pharmaceuticals. It has declared them applicable to whiskey in the Valentine case. More recently, it has declared them applicable to medical devices in the UNEC case, which we will deal with in a couple of minutes. And fairly recently, also in 2018, despite the fact that it's not a Court of Justice decision, it's a decision from the District Court in The Hague, they were also declared applicable to plant protection products, which of course everyone already did or applied in practice, but now it was also confirmed in a court case. So to start with the first BMS condition, as I said, the artificial partitioning of the market. This is how it was understood until some point in time. Only artificial partitioning of the market is unlawful. So not all partitioning, only to the extent that it is artificial. And partitioning is only considered to be artificial if there is an objective necessity to repackage. And there is only an objective necessity to repackage, according to the Court of Justice, if without the repackaging, the parallel importer cannot get effective market access to the market of the country of import. The mere fact that the parallel importer can gain a commercial advantage through the repackaging is, at least in theory, not sufficient. Also, although we will see that the lines between what objective necessity and commercial advantages have blurred over time. Now, this objective necessity needs to be assessed at the moment of importation and in light of the applicable rules and practices that apply in the country of importation, for example, reimbursement, prescription practices, or consumer interests. Also, it was understood that the way the repackaging needs to be done needs to be in the least infringing or intrusive way for the trademark holders. So a minimum amount of changes should be applied if you can do so. And finally, the burden of proof is on the importer. Now, the question is, how do we apply all these principles in practice? And as the picture on this slide already suggests, the pendulum has over time swung in many directions, particularly in the context of reboxing and rebranding. And at the end of the chapter, I will also briefly deal with relabeling in view of some recent examples. So to start with reboxing. Now, obviously, we cannot discuss all cases that have intervened over the past couple of years. It's not the purpose of this presentation to give you a full historic overview, but we mentioned this specific case, the Zocor case of 2006, because at some point in time it was the benchmark for practitioners like ourselves to advise companies on what was allowed in the area of repackaging of medicinal products and obviously also other products. So in this specific case, the parallel importer sought to import a product which was marketed in France under the name Zocor in a pack of a box of 28 tablets. And they wanted to import it in Belgium under the size of 84 tablets. And so the argument was, well, we need a new box for that. The Court of Appeal said, no, there's no objective necessity to rebox here because you can bundle in a cellophane wrapping and attach to that some stickers. That would be sufficient here. So you can bundle, you don't need a new packaging. We apply, says the court, the least intrusive way for the trademark holder, and according to us, this is it. Also, they say there is no evidence that there are rules or practices at that time in Belgium preventing the bundling of these products. In particular, they did not find any basis for such prevention in the 2001 royal decree, which applies to parallel import of medicinal products here in Belgium. And finally, they said, aside from the fact that there's no evidence that there are any objective rules or practices, government instructions that this would not be allowed. Furthermore, there is also no evidence of resistance of a significant percentage of consumers against this bundling and over stickering of the product. And in addition, they said, well, the criterion imposed by the Court of Justice is a significant percentage of the consumers who are against it. You did the poll amongst pharmacists who are not consumers. So the take-home message here from Zocor was that despite the fact that there are different pack sizes, you can bundle the product to the extent that it's a multiple of your original pack size. So 84 is a multiple of 28. So in such a scenario, you have no objective necessity to repackage. After that came a number of other decisions, but the most notable one was the Venno-Rutten decision in 2012, where the Court of Appeal said that there was no objective necessity to repackage a product which came from Portugal, where it had a certain amount of tablets, and the product was marketed in the exact same size, so with the exact same amount of tablets in Belgium. So the parallel importer said, well, despite the fact that the packaging is the same, we still need to rebox here because otherwise we would not be able to impose the Braille script in one example. And also we could not change the name. They wanted to change the name, as you see on the screen, slightly from Venno-Rutten Forte 500 milligrams to the Forte in the full name. Here, the Court of Appeal, as I said, they said, well, it's not necessary because, first of all, you proposed yourself originally to apply stickers. So apparently it's not that difficult to do. And secondly, indeed, you can overcome this by using stickers or applying stickers on the packaging. So the take-home message of the Venno-Rutten decision was, to the extent that there's a one-on-one correlation between the size of the product in the member state of export and the one in the member state of import, there will be no objective necessity to repackage. So these two cases and the ones in between were fairly generous to the trademark holders. That changed with the Omeprazole decision back in 2013, where the pendulum began to swing towards the other side. Here in this case, the parallel importer wanted to import a product. There were different products involved, but we take the Omeprazole example because it's the most notable. So there was a product, Omeprazole Centropharm in the Netherlands, and it was on the market in a box of 30 capsules. And in Belgium, they wanted to commercialize it in a package of 100 capsules. And so here the argument was made by the innovator company saying, well, it wasn't the innovator company, it was Euro Generics in this question, but nevertheless, it was their product that was being repackaged. And the argument was, well, why don't you just put the box of 30 that exists in the Netherlands as 30 on the Belgian market? It's not because you mention a number of other pack sizes in your marketing authorization that you all of a sudden would obtain an objective necessity to repackage. Here, the Court of Appeal, as a matter of principle, said that, well, the parallel importer should have access to the market segment of big boxes. And in this particular case, there was evidence that the big boxes in the treatment for which this product was intended was indeed preferred by doctors. It was a long treatment, so big packs were preferred, and there were also better reimbursement conditions. In addition to that, because the argument was also made based on the Zocor case law, well, why don't you just then, if you want big packages, why don't you just bundle? For example, you could bundle 4 packages of 30, you end up with 120, you bring them on the market as if they were 98. Here, the Court of Appeal said, well, first of all, it would be physically impossible to fit all of them into one box of 30, the original box. And with respect to the bundling, the court said, well, 98 is not a multiple of 30. So that would mean that if you indeed do what the other side had suggested, you would end up giving away 22 free tablets, which would not be in the interest of the parallel importer. So this marked the beginning of a change of view in of the Court of Appeal. And here, the take-home message of the Omeprazole case was that to the extent that there are different pack sizes in the country of origin and the country of importation, you will, in principle, have a right to rebox to the extent that you want to reach the target segment of big boxes. Implicitly, it can be inferred from this decision that to the extent that it would be physically possible to fit extra blisters into the original packaging, then there would be no objective necessity to repackage. This principle was then confirmed in the 2 COSAR cases of 2016. And as you can see on the slide, it involved 2 formulations of the product COSAR, one for 100 milligram, the other one for 50 milligram. In the first case, the parallel importer wanted to import from Italy a box or a number of boxes which were marketed there in 28 packs to Belgium, where they were only marketed at the time in 98 size packs. In the other case, there was a difference in the sense that not just the 98 packaging was on the market in Belgium, but nonetheless, the principle was the same. The parallel importer wanted to reach the market segment of 98. In addition to that, as you can see in the first frame, there was also an issue of rebranding, but I will deal with that when I get to rebranding in a couple of minutes. The original product in Italy was called Lortaan, so it had a different name than the one that was used in Belgium. Lortaan was not used in Belgium as a product name. So here the Court of Appeal, first of all, confirmed the Omeprazole principles. They said there's an objective necessity to rebox because there are different pack sizes, and basically denying the reboxing would prevent PI Pharma, in this case, from accessing the market segment of 98 as it was defined. But they went one step further here, because while in the Omeprazole case, they still, as a matter of principle, took into account at least the possibility that the product could be bundled. They just said it's physically, it's not interesting to bundle them because in the Omeprazole case, the bigger pack was not a multiple of the smaller pack size. Here they said, well, bundling is no longer allowed. And the basis for that was quite simple email from the Belgian Medicines Agency confirming to the parallel importer that from now on, they would no longer or not accept any bundling. So that was the basis for that decision. In addition to that, they said there's an objective necessity to rebrand, but as I said, I will come back to that in a minute. And this decision was also confirmed. Both decisions were actually also confirmed by the Belgian Supreme Court. Before I get to rebranding, I want to deal with the final chapter, so to speak, of the reboxing story, notably the Singular case, which is the most recent event to our knowledge. In this case, there was an attempt from a parallel importer to import, again, a box of 28 tablets as it was on the market in Poland, and they wanted to rebox it to the bigger size available in Belgium, the biggest one, which was 98 tablets. Now here, the difference with the previous cases was that the first instance court said, well, there's no objective necessity because the original box as it existed in Poland was big enough to fit an additional 5 blisters of 14 tablets. So they said to the extent that the box is big enough, then there will be no objective necessity to repackage because you can simply take the blisters and put them in the original package. The Court of Appeal in 2018 did not expressly confirm the decision of the first instance court, because the parallel importer acquiesced to the situation and they actually indeed put the extra blisters in the original product, but it can be inferred, at least implicitly, from the decision that the Court of Appeal agreed with the first instance court. So that brings me to the issue of rebranding. First of all, let me perhaps get back, if I may, to the slide on COSAR. As you can see here, this was the first case on rebranding, at least where the issue was discussed in such great detail, where the parallel importer wanted to use the name of the reference product of the trademark holder, the innovator product in Belgium, which was COSAR, because Lorton, the name of the product in Italy, did not exist at the time in Belgium. So the Court of Appeal, they said, well, that is no problem. According to us, there is not just even, you're not just allowed to repackage, but there's actually, to rebrand, but there's also a legal basis for the rebranding. On the allegation, and it was an interpretation by the Court of Appeal of the 2001 Royal Decree on the parallel importation of medicinal products, where they said, well, a parallel importer is only allowed to do what we call here reminder advertising. So he can only refer to the name of the product. And the Court of Appeal said, well, to the extent that you would force the parallel importer to use a product name, in this case, the Italian name Lorton, which nobody knows on the Belgian market, then that would lead to a severe restriction of its marketing possibilities. So therefore, they said you have an objective necessity to rebrand because you are so limited in the form of advertising that you do. So the take-home message here from the COSAR case is that to the extent that you want to market in the country of import a product, the name of which that is used in the country of export is not known in the country of import, you would have the right and even the legal obligation, apparently, according to the Supreme Court, to rebrand. The second case is the Prareduct case of 2015, where the situation was different. Notably, the question was whether you were allowed to rebrand to the name of the innovator product that was used as the reference product in the regulatory application for parallel import. And so the answer in this case was negative because the product as it was marketed in the Netherlands was a generic product, so pravastatine Ranbaxy. And in Belgium, the parallel importer in this case, they rebranded it to Prareduct, which was a product of Daiichi. And so the peculiarity of this case was the fact that despite the fact that it was the same ingredient, it's a generic product, the court said, well, there are different excipients which may cause the product to have different effects. But more importantly, the court said, there are different marketing authorizations for both products. They are not covered by the same marketing authorization. And even more importantly, both companies are completely unrelated to each other. They're different companies. They do not belong to the same concern. The one is Ranbaxy, the other one is Daiichi Sankyo. So in any event here, in this case, you do not have the right to rebrand. Now, this was discussed further in actually four other cases. The ones dealing with Femara, we call them Femara 1 case and Co-Diovan, and the other one dealing with the Femara 2 case and Rilatine. I will only deal with Femara to save time and also because it's an example that also applies to the other two cases. So, but in this first Femara case, the parallel importers sought to parallel import from the UK a product that was on the market in the UK as Letrozole Sandoz. And they rebranded it in Belgium to Femara, which is the name of the same product, but it's the name of the originator product as it is marketed by Novartis in Belgium, whereas Letrozole Sandoz obviously is the name of the product as it is commercialized by the generic division of Novartis, notably Sandoz. And here, the answer of the first instance court in Brussels was, first of all, there is indeed an objective necessity to rebrand because, and they referred expressly to the Cozar decision of the Supreme Court that I just mentioned. Well, at the time, it was the decision of the Brussels Court of Appeal. They said, well, letrozole Sandoz is not even on the market in Belgium. So therefore, obviously, according to the court, it would be impossible for the parallel importer to advertise for its product under a name that nobody knows. So applying the same philosophy, they said, well, for that reason, you are entitled to rebrand. And in addition, this court said, well, we also confirm that it's generally okay to switch between the generic and the innovative brand in this case, because not only is it the same product, but it is also covered by the same marketing authorization, and the trademark holder is the same entity, Novartis AG. So it's the same company, it's the same concern. Now, in the second Femara case, but in a conflict with a different parallel importer, and this principle was also applied in the Rilatine case, which, as I said, I will not discuss, a similar attempt was made to import letrozole Sandoz from the Netherlands as Femara in Belgium. And here, the first instance court clearly stated that the rebranding was not allowed, hence amounting to a trademark infringement, which is of course peculiar because another colleague of the same judge in the same court applied a different reasoning. But here, this judge of the Brussels Commercial Court clearly stated, according to it, that there was trademark infringement because there was no exhaustion. So this court did not even get to the principles of the BMS criteria, because these only apply to the extent that we are in a situation of exhaustion. Here, the court said there is no exhaustion because exhaustion only applies to the product as it has been marketed under the same brand, under the same trademark. To the extent that you change either the product or the trademark, there is no further exhaustion and the product cannot be further commercialized as such. So this was obviously a matter of principle, which made it up eventually to the Court of Appeal. Again, always the Brussels Court of Appeal, who decided to refer the matter for a preliminary reference to the Court of Justice. Now, this is interesting, first of all, as a matter of principle, because it shows that the Brussels Court of Appeal is willing to put into question its own exhaustion by concern doctrine, the one that it applied in the Omeprazole case, not so expressly and well reasoned as in these cases, but it can be inferred implicitly that that is what they meant in that case too, where, as I said before, Omeprazole Centropharm was marketed as Omeprazole Eurogenerics, and there they said, well, Eurogenerics and Centropharm are part of the STADA group, so hence a product that is put on the market by one of these entities is exhausted, and it doesn't matter if you then replace the name Eurogenerics with Centropharm or vice versa. So here they say, well, they could have applied this doctrine, but they decided to refer the matter to the European Court of Justice. And I'm not going to read out loud all the questions that you can see on the screen, but essentially the first question is, does it amount to an artificial partitioning of the market if in a situation as this one, the innovator trademark holder opposes the further commercialization of the product that was placed on the market in its generic version, where it is rebranded into the innovator brand. So in this case, Femara from letrozole Sandoz. And in addition, they asked the question, I think there's the other questions have disappeared from the slide in the transposition of the old version of the slides to our newer format. But the second question is essentially, when we assess this question, do we do that on the basis of the BMS conditions, or is there indeed, as the Brussels First Instance Court had decided, is there indeed some preliminary step where we simply don't get to the BMS conditions because there is exhaustion? And in the same context, is it relevant that both products are identical and have the same therapeutic effect? So that's the second and the third question. So apologies for that. We can send you the questions if you want by separate email, or you can see the reference from the CJAU case on the screen, and you can have a look on the CJAU website yourself. So reboxing, rebranding. On a very final point before I give the floor to Kirian on relabeling. Typically, relabeling, so that means applying stickers, is assessed on the very same ground as the reboxing. So the BMS criteria apply as such. This was confirmed by the Court of Justice long time ago in the Boehringer 1 case. But recently, the Court of Justice seems to have added another layer of complexity and seems to have suggested that there is some sort of de minimis threshold for companies to apply before, or courts to apply before you can even get to the BMS conditions. Because here in the UNEG case, which related, as I said before, to medical devices, the CJU said that if it's only a small label, which does not conceal the trademark and which designates the parallel importer as responsible for placing it on the market by setting out its details, barcode, central pharmacological number, and so forth, that simply doesn't amount to repackaging at all. So we don't get to the BMS criteria. Now, to be honest, I find as a bit confusion, and it's unclear whether this is some sort of, as I said, de minimis or preliminary step to even get to the BMS criteria, but apparently it has already been applied in practice. In the plant protection case that I mentioned before from the Court of The Hague, the court used this UNEC decision from the Court of Justice to offset it against the facts of this particular case, because here the court said, well, on this container, there was a new label which completely covers the original label, thus making it invisible. There's a new product name, and there's an own or a new Dutch language user manual. And so the Court of The Hague clearly said, well, this is not just a small label on an unprinted spot on the original packaging. So therefore, this does not fall within the category of UNEC. This was the argument that was made by the other party in this case. So the court said it's a big label, so hence we do get to the BMS conditions, and eventually on the basis of these BMS conditions, the product was found to be infringing. So that brings us to the second BMS condition and also the end of my part. I will give the floor now to Kirian, who will deal with the further BMS conditions and also the other grounds at the end of the presentation. So thank you.
Hi, good afternoon. I hope everyone can hear me well, but just let us know in the chat if that's not the case. So yes, turning to the second BMS condition. The second BMS condition is a condition which requires that the repackaging cannot affect the original condition of the product inside the packaging. Contrary to the first BMS condition, it's kind of an empty box, an empty chamber presently when it concerns or when it comes to Belgian case law. There's not a lot of Belgian case law, no Belgian case law on this particular issue. So there's only guidance from the Court of Justice of the European Union, which stated that, okay, you won't affect the original condition if you remove that product inside the packaging. You remove it from the original external packaging and place it in a new external packaging. There's no affecting that condition if you fix self-stick labels on the inner packaging. You can also add new user instructions or information or even an extra article. But what you can't do is omit important information from that external or internal or the packaging or the new user instructions, or you cannot give inaccurate information either. What you also can't do is adding an extra article which would actually go against what is envisaged by the original manufacturer and what is foreseen in the patient information leaflet. That's it for the second condition. Turning immediately to the third BMS condition. The third BMS condition is kind of the identity requirement. You need to, as a parallel importer, the parallel importer needs to state the entity, the name of the manufacturer, the original manufacturer, and also the entity that is responsible for the repackaging of that original product. The idea behind this, stating who is responsible for repackaging the product, stems from the fact that your trademark is designated to show whose product is this? And by stating that you repackaged it, at least the user, the end user, the consumer, is aware that this is no longer the original product. There are 3 cases that deal with this topic a little further. First case is from the Court of Appeal of Brussels in the Femodane case. It's a case where there was no mentioning on the packaging that Sharing was the original manufacturer. And instead, it was mentioned and it was argued, well, we state who is the parallel importer and its parallel importer registration. That should be sufficient. And if that's not sufficient, at least we have mentioned also the trademark of Sharing on the outside packaging. But that trademark or the reference to Sharing did not specify that Sharing was also the original manufacturer. And the Court of Appeal of Brussels stated that this was a violation of the third BMS condition. Second case, at the level of the Court of Justice of the European Union, the Orifarm case and the joint case on Paranova. In this case, what happened was actually that the packaging mentioned the parallel importer itself as the repackaging entity and not the entity that actually repackaged the product. And the question was asked to the Court of Justice, is there an obligation? It's always put differently. It's always starting from, does the trademark holder have the right to object to? But in se, it means, is there an obligation to mention the actual repackager? Can the trademark holder object if this is not done? The Court of Justice answered negatively. It stated that it's sufficient to mention the parallel importer on whose instructions the repackaging was carried out and who assumes liability for that repackaging. So the actual entity shouldn't be stated. And it motivated this decision by referring to, again, that rationale of this obligation. The end user, the consumer, now knows that the product has been repackaged, and there is no need to state who actually repackaged this product. A third case in Belgium, Court of Appeal of Brussels, a case that Philippe referred to before, is that of the Court of Appeal of Brussels of 2018 in the Singulier case. Here, in this case, what the parallel importer had done is only mentioning who had imported the product. So it stated imported by and then the parallel importer, but it didn't state who had repackaged the product. Now, importing and stating who imports the product is an obligation under the 2001 Royal Decree on parallel imports. And that does not affect what you have to do under trademark law. And repackaged and stating who repackages it, or at least on whose responsibility this is done, i.e. stating repackaged by, is an obligation under trademark law. As a result of that, the Court of Appeal of Brussels, as also in the Syngenta case, the Court of The Hague, stated that this is a violation of the third BMS condition, and it should be stated imported and repackaged by, for instance, and then the parallel importer. Fourth BMS condition. For the fourth BMS condition is a kind of container condition when it comes, because it refers to the reputation of the trademark and or the trademark owner. And in this regard, what I mean with container term, there are a lot of things that could harm your reputation as a trademark holder. And as we will see, there are a lot of things that have been argued to harm the reputation of the trademark holder as well. Now, the CGU stated that, of course, when considering whether that reputation is harmed, you should take into consideration also the nature of the product and the market for which it is intended. And it added to this, well, the pharmaceuticals is that's a sensitive area. It's an area where consumers pay a lot of attention to the product they receive, and whether there's untidy or poor quality or defective packaging. And as a result of that, that could indeed, such packaging could damage the trademark holder's reputation. What the Belgian courts have found is, an overview of what harms the reputation, weekdays that are mentioned or days that are mentioned in the foreign English language or only one language on the blister, and and it's insufficient, of course, when it's mentioned in the national 3 languages and the patient information leaflet. The patient should be able to know it was an anti-conceptive, a contraceptive. The patient should know on which days to take certain pills. There is also, if you attribute the trademark to a wrong entity, that could harm the reputation of the trademark holder. Using an obsolete version of the patient information leaflet, or even typographical errors, depending on the seriousness of those errors, of course. What doesn't harm your reputation has also been discussed in a number of cases, or results from a number of cases. On a first argument that was raised here is that there were different trademarks used on the inner and outer packaging. The outer packaging also mentioned the original brand, and the courts actually rejected that this would harm the reputation of the trademark's holder. If there is an identical getup, this is an argument that we will see pop up again when we talk about copyright and unfair competition, but there's always a discussion, should the parallel importer use a plain packaging, or should he actually adhere to the original packaging as closely as possible? Well, using an identical getup does not harm the reputation of the original trademark or the trademark holder. Passing of a generic as an innovator product also doesn't harm that reputation. Cutting blisters was even allowed in Femara and Co-Diovan, disputably, I would say, and different trademark colors on the packaging, despite the Belgian drugs agency having prohibited the innovator to do so. So in that case, in the Singulier case, the original manufacturer was prohibited from using multiple colors in the trademark. It should be one plain color. The parallel importer still used a double color. But the court rejected that this would harm the reputation of the trademark holder, considering that the trademark holder had used that two different colors before himself. Finally, the fifth BMS condition. I can be rather short about this. You probably all know that this concerns the notification obligation. The parallel importer should inform the trademark holder of its intention to put a parallel import product on the market. And on demand, if the trademark holder requests so, supply him with a specimen of the repackaged product. Now, in any event, the Court of Justice stated, so in any event, meaning that even if the trademark owner would be informed through other means or channels, for instance, by the authorities, that this parallel import or parallel distribution is upcoming, that is not sufficient. The parallel importer still needs to inform. And the notice should be sent within a reasonable time before the sale of the product on the market. That reasonable time, the Court of Justice has stated that indicatively, this is a period of 15 working days appears reasonable. So how to notify, and what rules apply then? First of all, a mock-up, only sending a mock-up is not sufficient. The parallel importer cannot refuse if the trademark holder asks for a final 3D sample to provide that final 3D sample. Secondly, the indicative term of 15 working days only starts upon receipt of the 3D sample, not upon receipt of the mock-up. However, of course, as a matter of diligence also, the trademark holder should already comment what he can if and when he receives the mock-up version beforehand. Also changes need to be notified to the trademark holder. So if the parallel importer would change something to the parallel import product, and it needs to be sent to the trademark holder, not the marketing authorization holder, the manufacturer, the patentee, or whatever. So it needs to go to the trademark holder, and it needs to go before the launch, not right before the launch, but a sufficient period of time should be given. And finally, the notification should be done by the parallel importer himself, like I said before, and this was confirmed in Syngenta. That was it on the trademark aspect. And that leaves us always with the additional question, are there also other grounds that the trademark holder, or at least, let's say, the manufacturer or the marketing authorization holder can rely on? And two grounds come into mind. The copyright is one, and unfair competition is another. So let's see what the courts have decided. And I think I can already tell you that just like for the BMS conditions and the first BMS condition, as Philippe explained you before, the pendulum has swung a little over time. So in earlier cases, the court stated that yes, you can rely on copyright, and copyright can be infringed by the parallel importer, particularly if there is an original element, of course. I mean, otherwise there is no copyright. And in Neoral, for instance, like you can see here, that original element was the volcano spitting out Novartis' trademark, and there was also a little man on the volcano. The composition of that outer box was subject to copyright and was infringed. However, in more recent cases, the Omeprazole case at the level of appeal and Singulier at the level of appeal, the Court of Appeal of Brussels has stated that you can't use copyright to prevent the further commercialization of a product that was actually allowed, or that is allowed, lawfully marketed under the BMS conditions. It referred to Dior, and to Dior afterwards also to Evora in the Singulier case. Also, the suggestion to raise a question for preliminary ruling was rejected by the Court of Appeal. It considers this to be clear. So in terms of copyright, it's becoming increasingly difficult, at least at the level of appeal. And if tried, it should definitely rely on original elements, clearly distinguishable elements, which are subject to copyright. Secondly, if trademark is if it's allowed under trademark, if it's allowed under copyright, can you still refer to unfair competition? Again, the pendulum has swung a little. Yes, the court originally stated you still can do that, but in recent cases, there's again that similar position that you can't rely on unfair competition to prevent a product from being marketed, parallel import product from being marketed in Belgium when it's allowed under the BMS conditions. It's in our view, there's Dior, Evora do not go that far to state that, for instance, the copyright can no longer be invoked. It's disputable. Definitely that your copyright or unfair competition would be that you can no longer invoke your unfair competition or copyrights or grounds of unfair competition or copyrights when you have when the trademarks test has been passed. So that's to sum it up. I think in terms of IP, falsified medicines will also deal with objective necessity, but in terms of IP, trademarks, copyrights, we've dealt with most of the issues here. I will go over. I see that we have about 10 minutes left. Over falsified medicines first, and see whether there's time to discuss the regulatory aspects as well. Falsified medicines. So in 2019, the Falsified Medicines Directive entered into force, and it imposed the companies, both parallel importers and manufacturers, and that's important. So parallel importers also need to comply with this, to apply two obligatory safety features: a unique identifier and an anti-tampering device. And for parallel traders, because they put a new box or a relabel box into circulation, again, they will have to apply a new unique identifier and a new anti-tampering device. Now, what is the impact on parallel trade? Two issues have been raised. First of all, does the Falsified Medicines Directive amount to a free pass for reboxing? Why? Well, the argument is that if you open the original box, you break the anti-tampering device, you need to break it. And as a result of that, you can no longer use the original box because it leaves traces breaking that anti-tampering device, and you need to use a new box. Well, this kind of free pass without looking at the concrete circumstances, there are some arguments against this. First of all, the Falsified Medicines Directive applies without prejudice to IP rights. So they are still in place. Secondly, Article 47A of the Community Code, introduced by the Falsified Medicines Directive, states that safety features may be covered. Covered, meaning the original safety feature is still there, and it can be covered by new safety features or other. Also, the Commission has answered to this question in a more general way as well. And question 1.20 of its latest Q&A, that's version 18, the question is asked, can a lawfully opened pack, so lawfully by a parallel importer, be resealed and reused? The Court of Commission, the European Commission says yes, that is possible if the old ATD can be replaced with an equivalent ATD, if it is replaced by an equivalent ATD. And that means one of the three cumulative conditions important here is that the new anti-tampering device must completely seal the pack and cover any visible sign of the original broken anti-tampering device. So in that case, yes, you can reseal the box and reuse the box. For instance, if the original anti-tampering device was a transparent seal, you put a new seal on top, the parallel importer does so, and the original seal and also opening the box, breaking the seal, that is covered, those traces are covered, you are fine according to the European Commission, or that should at least be possible. Also, an argument that is raised here, I think, and we've seen this, is that the inner box, well, because there's an anti-tampering device on the outer box, for instance, 84 tablets box with two 42 tablet boxes in that 84 tablets box, that doesn't mean that you also should be allowed to rebox the inner boxes, even if your ATD breaks the original outer box. The Swedish Patent and Market Court very recently actually took a position in this regard, and it rejected the argument that it would allow a free pass for reboxing. It stated that in the case at hand, there was no reboxing was not objectively necessary. It rejected actually an argument also made by the Swedish Drugs Agency, which was based on a wrongful interpretation according to the court of the Falsified Medicines Directive. It also rejected a testimony of a pharmacy employee for the same reason, and it referred to the recital 29 and article 74A, which I mentioned earlier. However, in Germany, the same question has led to a question for preliminary ruling to the Court of Justice of the European Union. And the question is actually, is there artificial partitioning of the markets if the parallel importer is only allowed to, or can only retain the original pack and replace the safety features in such a way that visible traces are remaining? So if you insist that he still does so and that visible traces remain, are you then actually artificially partitioning the market? So is this a possibility for the parallel importer to do so? And what if, and that's the second and third question combined, what if the traces become visible only, second question, if the medicine has been thoroughly inspected by wholesalers or pharmacies, but may be overlooked during a superficial inspection, or if the packaging of the medicinal product is opened, for instance, for example, by a patient, so that meaning if only then the visible traces become noticeable, visible, is that a possibility for the parallel importer to then use this type of resealing? An additional question, something that hasn't popped up yet, is must the unique identifier, and if it's not entirely on your screen, so must the unique identifier be printed directly on the packaging, or is an external sticker sufficient? Now, why does the court ask this? If it should be printed directly on the packaging, the parallel importer would need a new box. If an external sticker with the unique identifier is sufficient, it can use the original box. It's a second argument in that regard, and reference is made to Article 5.3 of the delegated regulation. Finally, a second issue that arises when it comes to Falsified Medicines Directive, what about equivalent anti-tampering devices? What is equivalency? And in this regard, the court states, the issue, the arguments are made if we look into the Falsified Medicines Directive and the Community Code. What does equivalency mean? Equivalency means that the new safety feature, when the original safety feature is removed and replaced by a new safety feature, that new safety feature should be equally effective in enabling the verification of authenticity and the identification of medicinal products and in providing evidence of tampering. So the question here is, if, for instance, the original box was actually had a breakable or tear-away closure, which breaks the original box, okay, in that case, the original box is no longer usable. Objective necessity will be very hard to argue. But can the parallel importer then use something a little less sophisticated, such as a sealing label, or is that not equally effective? You can ask the question also in this regard, can reference be made to the ISO or CEN standards? Well, the Commission stated that they are not mandatory, but they are available for manufacturers to consider. So arguments could be made on that basis as well. Now, under the BMS conditions, could you put it under one of the BMS conditions? For instance, the fourth BMS condition, meaning you've chosen for a tear-away closure for your own product because, for instance, it's a very valuable product. And putting this now in a new box with just a seal on top of it could harm your reputation as a trademark holder. That is about it for the falsified medicines. I think in first instance, I would like to ask whether there are questions. Philippe, can you see on the screen whether people have asked questions, and or whether no questions, and if you want me to continue and discuss three regulatory issues, it's three decisions of the Court of Justice of the European Union. The main idea here and the main question here is whether the parallel import product should be entirely identical to the reference product, or whether there can be slight differences. So the question is, what does the relation have to be in to the reference product? There have been three decisions from the Court of Justice of the European Union, 2019, and 2020. Essentially, what is clear from the three decisions, first decision is Delfarma, where a generic medicine was imported into Poland, where the generic medicine was not on the market, and it was imported as the branded product, the originator medicine. And Polish legislation actually required that the imported product and the reference product should be identical, either both an original or both a generic. The Court of Justice said that this was actually a violation of Article 34 of the the TFEU, the Treaty on the Functioning of the European Union. And it stated, well, if it's manufactured according to the same formulation, has the same active ingredient, and has the same therapeutic effect as the reference product, then there's no issue of quality, efficacy, and safety. And also stated that the community code, as a result of that, does not apply. If it's already put on the market, so you don't need a new marketing authorization under the community code. I think that's a doubtful decision. There's something to be said about this, because in essence it allows you to have a kind of a de facto community marketing authorization for generic medicines, and even more so, you can always put them on the market as the originator medicine, whereas you can at the same time say the parallel import product, the country of origin, there's no common origin, so there's no parallel import actually in this case. Court of Justice said quantitative restriction not justifiable under Article 36 nonetheless. Second case is the Vaislife decision. If you have questions, it's on a plant protection product, so I won't go into many details, where the same issue arose. In this case, it was not generic, but the manufacturer for the original product, the original plant protection product, and the reference plant protection product was different. Promaline was it in Italy. The product was VBC 476 in the Netherlands, and it was changed in Italy. It was still Valent Biosciences, and in the Netherlands it was Chrysal in the end. And the Court of Justice said in that case, you as a parallel importer, you should submit your file to the authorities, and you should show that the products are still identical. But there is a possibility that they are identical if the origin plant protection product is manufactured by company A, for instance, Valent Biosciences, while the reference plant protection product is manufactured by company B, for instance, Chrysol, under a long-term arranged consent of company A and using the same process. Last case, Colpharma. Colpharma, in this case, very recent. It's of October 8 of October 2020. There was parallel import of Impromen 5 milligram tablets, and the product, the tablet product, reference product, was no longer marketed in Germany. Only the drops product, the Tropfen, Impromen Tropfen, and the German Medicines Agency actually refused to change the patient information leaflet and dosage instruction with reference to the drops product. The Court of Justice in this case reminded actually that requiring the PI license to expire when the original reference product, the marketing authorization, is withdrawn, that is a quantitative restriction. So in this case, requiring to have all amendments to documents and particulars of the parallel import medicine approved is also a quantitative restriction. I think the Court of Justice here failed to note that it related to the patient information leaflet and essential documents to inform the patient, and that some sort of control by the national authorities is necessary and also desirable in such cases. Nonetheless, the Court of Justice didn't consider this to be the case, and it is everything okay? Okay, and said that the principle of proportionality was not observed, and that there was insufficient evidence of a risk to the effective protection of life and health. To conclude on what we've stated and what we've seen today, first BMS condition: if you have a one-on-one, then you can use or the parallel trader should use original packaging with stickers. If there's a different pack size, you can wonder whether everything is possible all of a sudden, although we have seen that if the original outer packaging can carry extra blisters and can fit the total amount of the bigger pack, that is also, or the smaller pack, that is, in that case, there shouldn't be reboxing. Rebranding, same question, is anything possible? Perhaps, unless we see that it is generic to an innovator brand, and we are hopeful that the Court of Justice will clarify early next year this issue. The other BMS criteria, like you've seen, it really needs to be looked at case by case, but there are a couple of pointers in earlier case law. The question remains, like I mentioned before, cutting blisters, is that really a possibility? Finally, other grounds to rely on are difficult, definitely at the Belgian level, where the Court of Appeal presently considers that these are also exhausted, that you can no longer invoke them, that it would lead to artificial partitioning if trademark rights have been observed and the BMS conditions have been complied with. On the falsified medicines, no objective necessity, at least in my view, but the question is raised if the no objective necessity. If the anti-tampering device leaves the original box intact and visible signs can be covered. I mean, if the transparent seal and the marks are covered by a new seal, then you should just be fine, and there should not be reboxing. And the obligation for the parallel importer to apply an equivalent anti-tampering device. What does this mean, and what is your right as a trademark holder? I think there are definitely some arguments to say that you should be able to verify that it is equally effective to your original anti-tampering device. Finally, the relation of the parallel import product vis-a-vis the reference product. Well, it seems that it shouldn't be identical to what is on the market, at least if the reference product is not or no longer available on the market of the member state of import. This should be, and not origin. Finally, just one last note. Well, first of all, of course, we're always very happy to have you here and to share some views and where necessary answer some questions, of course, as well. You can also read our views or our blog posts on our life and health blog. You can stay tuned. If you fill in your name and click on life and health and you submit, you will automatically receive our newsletters. The second life sciences session is foreseen on the 26th of January 2020. So this is the fourth Tuesday of the month, and that would be the fourth Tuesday as well. But we will communicate and invite you to our next session in any instance, topic to be determined. If you have suggestions, definitely feel free to send us. And apart from that, we like to thank you for your attention, for being here, and for listening to us. Thank you very much.